All right, everybody sit down.
All right, good afternoon, everyone. Thank you so much for being here for the final round of the 2025 Bork competition. Father Pignato is going to open us up in prayer to get started.
In the name of the Father, and of the Son, and of the Holy Spirit, Amen. Almighty God, we lift our hearts and our minds to you, and we ask you to look upon us with your favor and to send us your blessing, Lord, upon this competition and upon our school. We ask you, Lord, to give us a share in your wisdom. Help us always to seek the truth and to follow it in our lives. Please, Lord, give us all a deeper conversion to you, so that all that we do in life, all of our works, all of our endeavors may be for your greater glory. Through Christ our Lord, amen. The Father, the Son, the Holy Spirit, amen.
Thank you, Father. Good afternoon, everyone. My name is James Smirnikai, and I am the Moot Court Board President. Thank you all for being here, and a special congratulations to the finalists. This event is one of the true honors of our law school. It celebrates both the advocacy skills of our students and the values of excellence and professionalism that Ave Maria Law stands for. This year, we had 15 teams compete, and I want to congratulate every student who participated, whether they're here or in Commons 110. You have all put in a tremendous effort and should truly be proud of what you have accomplished. First, I would like to thank last year's Bork champions, Ms. Madison Maring and Ms. Madison Dees, for being present today. I would also like to thank the many people who made this competition possible. To our students who volunteered as criers, thank you for keeping the rounds running smoothly. To our faculty, thank you for stepping in to judge rounds, grade briefs, and mentor teams. Your support genuinely elevates this experience for our competitors. And most importantly, I would like to give a very special thank you to Emily Mugros, the Vice President of Internal Competitions. The planning that went into this competition and all of the work and hours you spent working on this competition truly made it shine. You made this easier for me and the entire Moot Court as a whole, and we are all very blessed to have you as the Vice President of Internal Competitions. So thank you very much. No other round. Come on. And now I'll hand it over to her for a few remarks.
Thank you. Good afternoon again, and thank you so much for being here. My name's Emily Mugros. I'm the current VP of Internal Competitions for this year's Moot Court Board. I want to echo James' gratitude and extend a heartfelt thank you to everyone who volunteered their time to make this competition happen. At this time, I'm honored to introduce our distinguished panel of final judges. Joining us, we have Dean John Zarnetsky, Dean, Professor of Law, and CEO of Ave Maria School of Law. Thank you for being here. We have Judge Kyle Dudek, United States District Court Judge for the Middle District of Florida, Fort Myers Division. Thanks for being here. And last, we have Richard Montecalvo, Chief Assistant State Attorney for the 20th Judicial Circuit of Florida. Each year, the Moot Court Board publishes its periodical, The Gavel. This year's title is Across the Border, Immigration and Tariffs. Our Bork problem addresses a related constitutional question: whether fingerprints obtained after an unlawful stop may be suppressed in a subsequent illegal reentry. Our competitors have spent weeks grappling with the constitutional implications, the scope of the exclusionary rule, and how far its protections extend in the immigration enforcement context. Their preparation and dedication have been exceptional. Thank you all again for being here to celebrate the hard work of our students, and we hope you enjoy the final round.
All set? All right, good morning, council, or good afternoon. To get us started then, we can go ahead and have petitioner come to the lectern and present their case.
Mr. Chief Justice, and may it please the court, my name is Jacob Wade, and I, along with my co-counsel Joseph Collins, represent Mr. Reyes Garza, an undocumented immigrant accused of violating USC Section 1326, addressing illegal reentry into the United States. We humbly ask this court to reserve 2 minutes to provide an adequate rebuttal to the respondent's argument. Thank you. What makes Mr. Garza's case unique and his prosecution unjust are the clear and blatant unconstitutional methods implemented and supported by the federal government to procure his arrest. Mr. Garza's constitutionally recognized privacy interests were invaded in 2 ways. First, Mr. Garza was stopped through an unconstitutional general crime control checkpoint clearly against the Fourth Amendment. As a result of the stop, Mr. Reyes Garza surrendered his license, which was rightfully suppressed at the trial court. Second, Mr. Reyes Garza was forced against his consent to submit to a fingerprint scan, despite a glaring lack of reasonable suspicion and no hits or issues otherwise procured by scanning his license. At the trial level, the court held that Lopez Mendoza bars the suppression of identity evidence in immigration proceedings, and the appellate court wrongfully refused to consider the presence of an egregious constitutional violation. My goal here today is first, to show that the district court erred in adopting their interpretation of Lopez Mendoza, and second, show that even if the court does not agree with our interpretation of Lopez Mendoza, as many circuits do, that the court should still find independent grounds for suppression or reverse and remand for further facts on certain issues in this ground. Should the court entertain suppressibility under the more accurate Lopez Mendoza interpretation, my co-counsel will further demonstrate that the fingerprints were taken for investigative purposes and that suppression is supported under the Hudson test. In determining the Lopez Mendoza interpretation, the district court cited Del Toro Godino. This stated that they used the word never, and this never in absolute language should be used to interpret Lopez Mendoza, meaning that the identity of the defendant can never be suppressed. However, this cursory analysis has been critiqued by modern courts and fails to analyze the opinion within the entirety of its context. Such strict language has been critiqued, and beyond the language of this opinion, there is the consideration that must be made for the separation of consolidated defendants. In Lopez Mendoza, there were 2 defendants brought up on appeal. The first of these was Lopez Mendoza. The second was Sandoval Sanchez. The first defendant objected only to the jurisdiction of the court and did not object and waived any objection to evidence presented against him. The court quickly dismissed his claim by reciting the controversial jurisdictional rule at issue and did not discuss any evidence that they failed to make an objection against. When reviewing the defendant's second defendant's objection, the court took great care to separately address the objections to the jurisdiction from the objections to evidence. The court carefully evaluated the merits of the evidence and the applicability of the exclusionary rule in that specific proceeding. Such a stark separation in the analysis should put this court on notice that Lopez Mendoza was only intended to refer to jurisdiction.
Let me ask you, while you're on that subject of Lopez Mendoza and the opinion, the words that are used by a lot of the courts are, it's very black and white, it seems to be. It says never.
Yes, Your Honor.
Was the use of the word never in the component of the case where you talk about jurisdiction, or is it in the component of the case where it talks about the evidence?
Yes, Your Honor. Del Toro Godino did use that never as persuasive authority, and we believe that that can still very much be true while still applying to only a jurisdictional rule, which we do not have at issue here. Here we're arguing over the suppression of the defendant's fingerprints, not the defendant's identity himself. If it was a jurisdictional rule, which we believe that it is, the defendant could not object to the jurisdiction of the court, which in the present action he is not. What we hold is that this should not extend to evidence discerning his identity, and that that interpretation fails to encompass the proper analysis under Lopez Mendoza. The most compelling justification for addressing the Lopez Mendoza identity statement are the 3 cases that Lopez Mendoza cited as justification for that statement. The first of these was Frisbee v. Collins, where the court specifically addressed, quote, forcible abduction of the defendant and bringing the defendant to trial against his will. This was a clear and narrow issue that the court addressed, dealing with a denial of the jurisdiction of the court. The second, Gerstein v. Pugh, the court specifically addressed a narrow probable cause determination and probable cause holdings, and the court's rationale was that there did not need to be an adversarial probable cause holding, merely judicial review. But this again was contesting an alleged unlawful arrest and did not address any evidence pertaining to the identity of the defendant. Finally, the last one, Bilikumsky v. Todd, it's where the defendant sought to contest the jurisdiction of the court by alleging a presumption of citizenship. He was facing deportation, but instead said that he should be presumed a citizen unless the court were to prove otherwise. And by making this assertion and claiming presumption, he was contesting the jurisdiction of the court. At no point did he contest any evidence pertaining to his identity. The court ultimately held that he was not entitled to a presumption of citizenship, but nevertheless did not address any substantial evidence or the exclusionary rule in that issue.
So your argument is identity is suppressible here?
Yes, Your Honor. My goal today is to show that identity is possible to be suppressed, and then my co-counsel will discuss why the fingerprints are the proper remedy for suppression. The exclusionary rule is the proper
The fingerprints
remedy.
are the identity.
They are identity evidence, Your Honor, because they indicate the identity. Here we're not interpreting it, or we're not holding the interpretation that would be protesting the jurisdiction of the court, but rather that it's evidence pertaining to the identity. And that we hold under the correct interpretation would be suppressible. Each of the cases that I mentioned specifically deal with contesting the court, contesting jurisdiction, or contesting an unlawful arrest. They do not deal with the evidence presented against the defendant or the admissibility of the evidence under the exclusionary rule. Based on these citations to legal authority, Lopez-Mendoza clearly intended the mere restatement of a jurisdictional rule. Since the language would lead to an overly strict result under Del Toro-Godino, the defendants were analyzed distinct from each other, and the court's precedent clearly supports a jurisdictional statement. The court should adopt this approach that allows for the suppressibility of the fingerprints, as it best protects the constitutional rights of the defendant and best gives weight to the clear purpose of the court in Lopez-Mendoza. Even if the court were to refuse to adopt this interpretation of Lopez-Mendoza, the court should still reverse and remand at the very least on the findings of an egregious constitutional violation.
Mr. Wade, before we get to that, I haven't heard you discuss whether or not it makes a difference that this was an administrative stop. Can you talk about that a little bit?
Of course.
If we find that this was merely an administrative stop, doesn't that answer the question against your client?
Your Honor, that is one of the approaches that the court could use under the exclusionary rule to determine the merits of exclusion. My co-counsel will further address this in much greater detail, but we do believe that the language of the record and the testimony of Officer James and the language from ICE for Operation Mass Sweep both clearly indicate investigative intent by the nature of the stop itself. We see that it was to refer for prosecution people who have committed crimes against immigration, and the officer even admitted in his testimony that it was for people who may have had warrants or other incidental criminal offenses. Such would lead to clear investigatory nature of the stop, and it would likely be investigatory.
Well, does the fact that there might be incidental facts that come to light vitiate the intent of it being an administrative stop?
No, Your Honor. Oscar Torres specifically stated that even if there was a mixed intent between criminal and civil with regards to stops or investigations, that the investigative would still predominate in that instance. There are two main approaches for measuring a egregious constitutional violation.
How are we supposed to measure that?
Your Honor, multiple circuits have implemented multiple tests. The first that I would like to discuss is the bad faith approach, which holds that there's either actual or constructive bad faith present on behalf of law enforcement in the violation of the constitutional amendment. The violation does not need to shock the conscience, and race-based stops under this approach always qualify as egregious. Here, what we see is a checkpoint that is in clear violation of well-settled Fourth Amendment principles by this very court, such as in Ferguson or Edmond, which have respectively required individualized suspicion and prevent checkpoints that merely perpetrate general law enforcement functions.
Was this an intended race-based stop?
No,
or
Your
a
Honor.
race-based operation?
Your Honor, the facts in the record do not fully indicate what the motives of the officer were, but we do clearly see that there was a lack of reasonable suspicion and that the stop by its very nature was also violating the Fourth Amendment.
Should we be looking at the actions of the officer or the operational plan itself to get those answers?
The intent of the officer would be relevant with regards to a racially motivated stop. The dissent in the appellate court in this action specifically stated that it would be proper to reverse and remand for further fact-finding on the presence of racial motivation or pretext. And on that note, we do request a reverse and remand on this ground because there's not enough information in the record. But what we do see
Alternatively.
yes, Your Honor.
Let me ask a question on that. To
Yes.
follow up, you said that we should, to determine the issue of the stop and whether it was investigatory versus administrative, we have to look to the intent of the officer. Is that what you indicated?
No, Your Honor. For the presence of racial discrimination or pretext, we would
Okay.
have to look to the intent of the
But
officer.
then to back up a little bit, if you're talking about an administrative versus an investigatory stop, if the officer was out there and it was told that this is an administrative stop, or this is an administrative function, everything is administrative, how do you get an investigatory stop out of that?
Your Honor, the language of Operation Mass Sweep indicated otherwise very clearly.
So you're saying it's from, when we look at the mass sweep, I guess I would call it memo that's in the record, you're saying that's predominantly investigative, so we can just take that as accepted?
Yes, Your Honor. I believe that the record does reflect that it is investigative in nature, but furthermore, the Hudson test was applied by the appellate court, and as my co-counsel will discuss in much greater detail, this would also support suppression under independent grounds as well, depending on what approach the court would choose to go with.
Before you talk any further, I do have one question.
Sure.
So you are asking us to suppress the evidence of his identity, of your client's identity, and that is the only element that's relevant to this identity-based offense. So if we agree with you and we suppress that, there's no evidence to convict your client, correct?
It would be a predominant element of the conviction, yes.
I mean, it's the only element. isn't it?
The illegal reentry would also have to be shown. I
Okay, the
believe.
illegal, I understand that, but I mean, at the end of the day, the main evidence is your client's identity. So if we agree with you and that's suppressed and your client walks out, then he's, again, still illegally in the United States. So we're going to sanction an ongoing criminal conduct in the release of your client? How does that work? How do I address that?
Your Honor, the constitutional rights of the defendant are of utmost importance, and the law enforcement should not violate constitutional rights in order to seek a more convenient or less intensive conviction. Furthermore, if you do not allow the exclusionary rule for the defendant in the issue, you leave him no remedy, so that officers are almost in every instance incentivized to violate the Constitution, knowing that if suppression is not the remedy for, as you said, one of the most predominant parts of the evidence for his conviction, he has absolutely no remedy, and alternative remedies for a illegal immigrant or undocumented immigrant are further limited, as my co-counsel will discuss in greater detail, due to the fact that they may be facing deportation and otherwise have a lack of resources for suits against constitutional violation offenses.
Thank you, counsel.
But the remedy for your client is essentially being set free on this stop and continued criminal conduct. This is not like your client committed a robbery, time and place crime, evidence is suppressed, he's set free. He's not committing another robbery. That crime is complete. This crime is ongoing. So isn't there an absurd element to allowing him freedom at this point when he's continuing to commit crimes against the United States?
Your Honor, if the defendant must go free in order to preserve the constitutional integrity of the Fourth Amendment, then that is what we believe is the most proper interest and most consistent with Lopez Mendoza.
But he goes free into the realm of criminality. He is continuing the crime of reentry.
Yes, Your Honor, and if
Illegal reentry.
if he were to be arrested under constitutional grounds and constitutional stops that are consistent with Terry or otherwise probable cause, that would be sufficient for a conviction, assuming the evidence was obtained under the Constitution. But the issue is if the court denies suppression of the evidence at all, they then give any undocumented immigrant under a 1326 prosecution no remedy at all and almost a guaranteed conviction, regardless of if the Fourth Amendment was followed at all.
Has this record created evidence for a future prosecution of illegal reentry? Your admissions here today, the record below, if he were to be released from jail tomorrow, couldn't ICE be waiting for him to pick him up immediately and then use this record of this case against him in a illegal reentry prosecution?
Your Honor, I'm not aware of if this record would apply to any future prosecution.
Okay.
Your Honor, I see my time has ended. May I briefly conclude?
You may.
We request that this court allow suppression under either the approaches that the various districts have held, bad faith, or the totality of the circumstances under egregious violations. Alternatively, we urge this court to adopt a widespread exception as listed in Lopez Mendoza, given the gravity and expanse of Operation Mass Sweep. And finally, we ask that this court reverse and remand for further fact-finding on the presence of pretext or racial discrimination. Thank you.
Thank you, Mr. Wade.
Mr. Chief Justice, may it please the court. My name is Joseph Collins III, and I, along with my co-counsel, Mr. Wade, represent Mr. Reyes Garza. Your Honors, this is a case about requiring the government to follow the law when seeking to prosecute non-citizens in illegal reentry proceedings. Because the proper interpretation of Lopez Mendoza does allow for suppression of identity evidence as established by my co-counsel, this court should allow Mr. Reyes Garza to suppress his fingerprint evidence. However, because of a split between the circuits, two approaches have emerged for this issue. The first approach, following criminal law, suppresses Lopez Mendoza identity evidence that is obtained for investigative purposes but not for administrative purposes. The second approach, rather, uses the Hudson cost-benefit balancing test rather than Lopez Mendoza to determine whether suppression is the appropriate remedy for the case at hand. However, Your Honors, regardless of the approach that is adopted by this court, both support the conclusion of applying the exclusionary rule to Mr. Reyes Garza's case. Firstly, Your Honors, the traffic stop and taking of Mr. Reyes Garza's fingerprints was done for investigative purposes. Therefore, Mr. Reyes Garza's fingerprints are suppressible. Lopez Mendoza, as established by Mr. Wade, permits suppression of identity evidence obtained for investigative purposes. as stated in both Garcia Beltran and Oscar Torres, fingerprints taken for investigative purposes are suppressible in criminal proceedings, and an investigative purpose would be any purpose beyond establishing the suspect's identity, such as connecting them to alleged criminal activity. While on the other hand, fingerprints taken for administrative purposes are not suppressible in criminal proceedings, and an administrative purpose would be the purpose of simply verifying the suspect's identity and nothing more. Here, just like in Davis v. Mississippi and Hayes v. Florida, Mr. Reyes Garza's fingerprints were taken for investigative purposes. In both of those cases, the court held that fingerprints taken for purposes beyond verifying a suspect's identity, such as directly trying to link them to alleged criminal activity, are taken for investigative purposes and are suppressible. Here, Your Honors, the purpose of the traffic stop was to investigate Mr. Reyes Garza. ICE's Operation Mass Sweep specifically requested local law enforcement to, quote, set up checkpoints and conduct raids in order to identify illegal aliens, and to refer these aliens to the U.S. Attorney for prosecution. Officer James said himself that at the checkpoint, he was checking people's IDs to see if they were in violation of any immigration laws and to see if there were outstanding warrants against any of the people stopped. Officer James had verified Mr. Reyes Garza's identity after stopping him at the checkpoint and checking his driver's license. Officer James then took Mr. Reyes Garza's fingerprints for the explicit purpose of determining whether he was involved in any violations of immigration law, which is an investigative purpose.
Where should we be focusing? On the conduct and comments of the officer or the contents of the memo? Where should our focus be to make this distinction?
Your Honors, we believe that this is a combination of both the language of the memo itself as well as the actions of the officer. The memo explicitly stated that it was granting local police departments broad discretion in how it was to go about conducting these checkpoints, as the 14th Circuit itself even stated when it used the Hudson test that the memo seemed to encourage local officers to violate the rights of those traveling on the roads. So the memo itself granted broad discretion to the local police departments and how they would conduct this. Officer James himself, his actions also show how he was doing this for an investigative purpose, as he said that he was checking IDs for immigration violations and outstanding warrants and was just seeing if there were any hits coming up for either. We believe that these purposes taken together show how the checkpoint was investigative in nature, even under the guise of it being an administrative traffic stop. Like in Davis and in Hayes, the government here was conducting investigatory stops without probable cause or reasonable suspicion for the purpose of taking people's fingerprints to determine if they were involved in criminal activities. The checkpoints outlined in Operation Mass Sweep, like the one that stopped Mr. Reyes Garza, are part of a nationwide investigation to identify and prosecute non-citizens.
Counsel, I want to interrupt you and switch gears to talk about the Hudson test, because you indicated that if we analyze this case under the Hudson test, we come with the same result, which is we should suppress the fingerprints, correct?
Yes, Your Honor.
I guess, the major concern I have with applying the exclusionary rule in this context is what we had talked about earlier, which is that if we do, we're going to essentially sanction a continuing crime the second we release your client. Meaning he walks out the door, he's committing a crime, and he could be picked up right then, a week from then, 3 months from then. So why should we apply the exclusionary rule in that context?
Your Honor, you are correct that if Mr. Reyes Garza were to win his suppression motion, he could simply be arrested as he leaves the courthouse lawfully. However, Your Honor, as Justice Clark said in Matt v. Ohio, the criminal goes free if he must, but it is the law that sets him free. Nothing can destroy a government more quickly than its failure to observe its own laws, or worse, its disregard of the charter of its existence.
But wouldn't you agree with me that the Hudson balancing test has a practical component to it? Meaning you have to weigh several factors to make essentially a decision based upon those factors and their practical application as to whether the exclusionary rule should be applied here. So for example, in Hudson, it was a knock and announce violation, right? And they said, well, it doesn't make sense to have the exclusionary rule apply if you did that, if you had that type of constitutional violation. Well, here, it's slightly different, I understand, but at the end of the day, again, your client has a continuing violation of the law the moment he's free. So what's the practical effect of us applying the Hudson test here in the exclusionary rule? We just let him go?
Your Honor, we believe that the three factors of the Hudson test all do support applying the exclusionary rule to Mr. Reyes-Garza's case, because the social cost of applying the exclusionary rule here are low, while the incentives for law enforcement to violate the Constitution are very high.
Well, what about, how is it low if we're, that first cost, the societal cost, we are allowing someone who's committed a crime to walk out the door free? And you would agree with me, you agreed earlier that he is committing a crime, so how is that not a high societal cost?
Your Honor, it is not a high societal cost because a person's identity is still afforded Fourth Amendment protections, as was stated in both Davis v. Mississippi and Hayes v. Florida. Although denying suppression of somebody's fingerprints obtained in violation of the Fourth Amendment could be viewed as a low social cost in isolated circumstances, when taken in the aggregate, this would create massive social burdens. The government could easily succeed in illegal reentry proceedings by simply proving a defendant's identity, which the defendant would now be unable to suppress, and the defendant's illegal presence in the United States, which is evident if the defendant is being charged with illegal reentry in violation of 8 U.S.C. Section 1326. It would be a very high social cost if people who are still afforded Fourth Amendment protections are in essence destined to lose because they would be unable to suppress an essential element of the government's case against them, regardless of whether the government followed the law when obtaining that evidence against the defendant. If Operation Mass Sweep is a nationwide ICE directive, surely others, like Mr. Reyes-Garza, were stopped and are possibly being charged. If no one stopped by these checkpoints or otherwise had identity evidence obtained in violation of the Fourth Amendment was able to suppress that evidence, it would create massive social burdens.
Well, what about, the third factor then of the Hudson test is the availability of alternative remedies. So on the one hand, I see it as you've got a bunch of factors here, but on the one hand, you're saying, well, the government can just act with impunity. They can go out and fingerprint people who they don't have suspicion for. But on the other hand, you have your client who's admittedly violating the law and will continue to violate the law every moment he's free. So you have bad actors on both sides. So maybe the tie-breaking factor should be the fact of maybe we don't let your client violate the law illegally, but we give him an alternative remedy of like a civil violation. Why isn't that a sufficient remedy here and not use the exclusionary rule, but say, well, he's got a civil remedy, but he has to leave the country, but he has a civil remedy against that officer who illegally detained him. Why isn't that a sufficient outcome under the balancing test?
Your Honor, the 14th Circuit did note that the third factor was dispositive and did not apply because there were other remedies that Mr. Reyes-Garza could seek, such as a civil suit or internal police department discipline. However, we believe that the exclusionary rule is the most effective deterrent here compared to other alternatives, because non-citizens like Mr. Reyes-Garza are unlikely to succeed in civil suits against officers of immigration agencies because of limited resources or fears of retaliation, especially if he were to be deported.
Well,
Moreover,
his fear of retaliation, he wouldn't be here. What's his retaliation? That the officer can't stop him again. He's going to be in his home country. So it would seem that there'd be no concern of retaliation. He'd have a civil lawsuit.
Your Honor, we believe that these are examples of the problems that non-citizens could face as, because they are here illegally, it might not be retaliation if it is done by an actual legal system, but it could be retaliation in other methods, as maybe the government would seek to, if Mr. Reyes-Garza were to win his suppression motion, but then were to seek a civil suit, we believe that this fear of retaliation, even if it's not well-founded, is enough that would cause a non-citizen such as Mr. Reyes-Garza to not engage in this type of remedy, even if it was possible for him.
You're asking us to speculate at this point. That's not a legal footing for us to make a decision on. What may happen, should that play into any role? Should that play a role in our decision-making?
Your Honor, we are not asking you to speculate on this case. We are trying to prove that the exclusionary rule here, compared to other possible alternatives that Mr. Reyes-Garza could seek, is the most effective to be applied to this case. As you are right, these other alternatives would require levels of speculation and facts in the record that we simply do not have. Moreover, Your Honors, internal police department discipline here would be an adequate remedy faced against an officially authorized ICE directive, such as Operation Mass Sweep, that gives police broad discretion in how they seek to accomplish the goals of the operation. As Officer James himself says, he didn't have much of a system. He pulled over cars every once in a while based on gut feelings, the length of time between them, or the appearance of the car. The exclusionary rule acts as a deterrent by requiring law enforcement to follow constitutional guidelines when seeking to seize evidence and then present that evidence against the defendant. If the defendant could never suppress his identity evidence, police would be motivated to violate the Constitution to obtain it because there would be no repercussions for their illegal activity, and that evidence would always be admissible regardless of the constitutional violation that occurred in obtaining it.
But that is the most extreme remedy for you, right? Applying the exclusionary rule. I mean, not every Fourth Amendment violation is a violation of the exclusionary rule.
Yes, Your Honor. The exclusionary rule, although it is an extreme remedy here, we believe it is the proper remedy, as other remedies would not adequately address the situation. Operation Mass Sweep, because it was given broad discretion to the police departments, if internal police department discipline was sought, Officer Aaron James could be very well disciplined for his action of violating the Fourth Amendment. But that would have no bearing on Mr. Reyes-Garza. He would not have his injury addressed in this situation, and he is simply told that although his constitutional rights were violated, that he is unable to seek any remedy. And in these situations where constitutional rights are violated in specific case-by-case situations that require factual analysis, the court has held that the exclusionary rule is that remedy to be employed in order to protect constitutional rights in certain situations when they warrant it. Additionally, Your Honors, the government conceded here that the traffic stop violated the Fourth Amendment. By not allowing suppression of Mr. Reyes-Garza's fingerprints, this would encourage law enforcement to violate the Constitution because the defendant's identity evidence would never be suppressible despite the constitutional violation in obtaining it.
But that brings us back to the Hudson test then.
Yes, Your Honor.
Okay.
Furthermore, Your Honors, the constitutional violation here strikes at the heart of the Fourth Amendment. The right of the people to be secure in their persons from unreasonable searches and seizures. The 14th Circuit admitted that it was concerned with Operation Mass Sweep because it seemed to encourage local officers to violate the rights of those traveling on their road. Additionally, Your Honors, the 8th Circuit held that by not allowing the exclusionary rule as the proper remedy, it could result in the widespread constitutional violations that were mentioned by my co-counsel. We believe, Your Honor, that the three factors of the Hudson test all do support applying the exclusionary rule to Mr. Reyes-Garza's case because the social costs of applying the exclusionary rules here are low. The incentives for law enforcement to violate the Constitution are high and would be sufficiently curtailed by the exclusionary rule.
Counsel, let me interject for a second. Part of the questioning you've probably picked up on from this point is our concern about the type of crime this is, because it's a continuing crime, meaning it happens every moment your client is present inside the United States. And as you heard from the bench earlier, you know, the suppression remedy is typically applied to a crime that's occurred in the past, meaning it's done and it's been, if the person walks out, they're not committing another burglary or a robbery, as you've heard. Are you aware of any other crimes that have a similar nature to being illegally present in the United States, meaning they are continuing all the time, as opposed to just a time and place crime?
Your Honor, the only example that I could give of a continuing offense like that could be if somebody were to break out of prison, as that is a continuing crime that is lasting for the entirety of their existence outside of prison where they were lawfully sent. And we do understand that this presents a very unique situation based on the type of crime. However, that is the price that we must pay to ensure that our constitutional rights are safeguarded. The government should not and cannot be allowed to violate somebody's constitutional rights simply to secure a speedy prosecution or because that prosecution would be inevitable. We cannot afford to sacrifice constitutional rights for the efficiency of law enforcement and criminal prosecution, because if the line is not drawn firmly, Your Honors, I see my time has expired. May I briefly conclude?
You may.
In conclusion, Your Honors, Mr. Reyes-Garza respectfully requests that this court reverse the district court's denial in part of his motion to suppress because Mr. Reyes-Garza's fingerprints were obtained for investigative, not administrative purposes and are suppressible, and the three factors of the Hudson balancing test all support applying the exclusionary rule to Mr. Reyes-Garza's case. Thank you.
Thank you, Counsel. All right, respondent.
Mr. Chief Justice, and may it please the court, the United States Congress has both the right and the responsibility to establish and regulate the immigration laws of this great country. As recognized by the Ninth Circuit and Peña Cabanillas, Congress's authority to exclude or expel all aliens is an inherent and inalienable right which is essential to the safety, welfare, and independence of this great sovereign nation. Furthermore, it is a primary duty of the executive branch to enforce those laws, including 8 U.S.C. Section 1326, which makes it a federal felony to re-enter this country after prior deportation without permission from the Attorney General. On September 15, 2020, the petitioner was arrested after his fingerprint evidence revealed a 2008 deportation order. Officer James arrested the petitioner and he was subsequently indicted by a grand jury under 8 U.S.C. Section 1326. Now, the reasonableness of this stop has not been preserved for appeal. Contrary to petitioner's argument, the government has not advanced a special needs in this case. Nevertheless, the fingerprint evidence is admissible for 3 reasons. I, Marie Carney, will discuss the first reason under Lopez-Mendoza, and my co-counsel Caroline Funk will address this court under the Davis and Hayes analysis and Hudson cost-benefit test. The first reason this court should deny the petitioner's motion to suppress is under Lopez-Mendoza. In Lopez-Mendoza, this court established the categorical rule that the body or identity of a defendant or respondent in a criminal or civil context is never itself suppressible as the fruit of an unlawful arrest. Courts have defined identity evidence as intrinsic identifiers or personal yet universal characteristics that can establish a person's legal identity. Examples of identity evidence include names, photographs, fingerprints, and facial characteristics. Due to its public-facing qualities, law enforcement can collect identity evidence without implicating the Fourth Amendment.
Let me stop you. Didn't Lopez-Mendoza say that the person's identity, it talked about their identity. It didn't necessarily talk about the encompass of all evidence that could be used to prove the identity. It just said that the person's identity. It focused on that, right? So would we have to extrapolate from that language in Lopez-Mendoza that it covers all the evidence that could be gathered regarding the person's identity? Is that your argument?
Under Lopez-Mendoza, the categorical rule states that the body or identity of a defendant is never itself suppressible. And because in this case fingerprints are identity evidence which tell who Mr. Reyes-Garza is in this...
Let me stop you there. You added an extra word when you talked about, you said identity evidence. That's not in Lopez-Mendoza, is it? It just says identity. So we have to expand Lopez-Mendoza, is what you're arguing.
While under this categorical rule, because the Kerr-Frisbee doctrine, which was already established as a longstanding principle that you can't suppress jurisdiction over defendant, Lopez-Mendoza, it would be illogical for Lopez-Mendoza to merely restate this principle. And in this case, because the identity of the defendant is his fingerprints, which reveal who he is, this can't be suppressed, as well as other circuits, other courts have stated that this applies in the criminal context to identity evidence.
So in this case, the officer had a mobile fingerprint machine, correct?
Yes.
And he was able to match those prints to a database, correct?
Correct.
What if the officer had a mobile DNA testing machine and demanded that he take a buccal swab of the defendant's saliva and put that into the machine and it came back to a match in a DNA database? Would your argument maintain?
While the collection of DNA specifically would be different because the fingerprints identify who he is, and in this case...
Well, DNA could identify him too, potentially.
That is correct. This court could qualify that as an egregious violation if that were the case. However,
but what's the difference?
The difference between the fingerprint evidence collection, and a DNA buccal swab would be intrusive to the defendant itself, whereas the fingerprint evidence, Officer James peacefully requested this evidence due to a language barrier. This was
Didn't he grab
collected.
his hand and make him essentially give the prints by grabbing onto his hand and putting his fingerprints on the machine?
While Officer James did take his hand, Officer James in the records went to him to try to communicate and collect the evidence.
You would not qualify that action by the officer as intrusive?
This would not be intrusive because, as courts have stated, like egregious violations could include breaking into a defendant's home and forcibly extracting pills from their stomach. That was the case in Roach v. California. Additionally, like a warrantless nighttime raid would be an egregious violation of their rights. Whereas in this case, that is not the case. This is to Officer James collected the fingerprints to ascertain his legal identity. And because of this reason, the fingerprint evidence cannot be suppressed. Furthermore, while the petitioner has stated that Lopez-Mendoza only applies to jurisdiction over the defendant, this interpretation is flawed. The majority of federal courts have broadly applied the Lopez-Mendoza rule, holding that neither a defendant's identity nor identity evidence can be suppressed under the Fourth Amendment in 8 U.S.C. 1326 prosecutions. Lopez-Mendoza's rule extends beyond jurisdictional power and encompasses all identity evidence. As stated in Del Toro Gudino.
Counsel, your argument is this was an administrative stop, correct?
Correct.
But your introduction highlighted the role and responsibilities of the United States government to get criminal aliens out of the country. So how do you comport your introduction to your argument that extolled the requirement or the virtue of the United States government to crack down and get illegals out of the country with your position that this was simply an administrative stop?
Yes, Your Honor. While it is Congress's authority to exclude or expel aliens, and this is the executive authority in place by the law, under the administrative approach, it's based on the officer's sole purpose and motive in the stop. And in this case, Officer James's purpose was because it was a mucky or dirty car that was seen on Respondent's Appendix, page 14. So in this case, it is an administrative stop because it was simply to ascertain the defendant's legal identity. It was not because of a underlying purpose otherwise with Congress's authority.
How does a mucky or dirty car relate to someone's identity?
While the purpose of the stop was because the car was mucky or dirty, it was not to influence a race-based violation. The record is void of any race-based violation in this case. So the officer's motive was not because of race, and therefore it cannot be egregious under this purpose. As stated in Del Toro Gudino, indeed it is hard to argue that never means hardly ever. This court specifically used the word never in referring to whether identity evidence is suppressible, and thus the categorical rule applies. In contrast, the minority of circuits interpret Lopez-Mendoza as referring only to a court's jurisdiction over the defendant, consistent with the Kerr-Frisbee doctrine, which holds that jurisdiction is unaffected by an unconstitutional arrest or seizure. However, Kerr-Frisbee does not bar suppression of identity evidence obtained through Fourth Amendment violations, and it would be illogical to read Lopez-Mendoza as merely restating this long-established principle, that the criminal defendants cannot object to the court's exercise of jurisdiction over their physical body. Thus, Lopez-Mendoza extends the Kerr-Frisbee doctrine beyond jurisdiction and applies to identity evidence. Moreover, adoption of this interpretation would lead to untenable consequences and should be rejected.
Let me interject there because you're talking about untenable consequences. Let me ask you this. If we do not suppress the evidence of the illegal fingerprints, what would stop officers from just posting up on 75 and pulling over every person on 75 and fingerprinting them?
While that could be the case, this specifically is an ongoing violation of a crime in the United States, and the exclusionary rule is a judicial remedy. It's not an absolute right. So in this case,
I know, but if we're gonna institute a rule here applicable to this particular client, but that rule is gonna have the force of law across the spectrum, meaning it doesn't just apply here. So if we say, nope, we're not gonna exclude that evidence, what would stop your officers from pulling over every person that drove down 75 and saying, I want to fingerprint you right now, and then taking their fingerprints? It would never be excluded, right? They could do that. What would stop them from doing that?
while the officers in these cases there could be remedies outside of that with the civil actions that the defendant could bring about against those officers. However, the social cost, as my co-counsel will explain, of an ongoing violation of violating the law of this country far outweighs the deterrent effect.
I drive I-75 every day, and I'm a United States citizen. And you're saying, well, the remedy for a violation of my constitutional rights is simply to sue somebody? I mean, is that the way we want to apply constitutional principles? They can be violated, and maybe later I can seek a remedy civilly?
In this case, because of the social cost of the ongoing violation, while that could be a citizen of the United States that is stopped, that is a remedy for this court for the courts. That's how the remedies are brought about.
Isn't the social cost the ongoing continuous violation of the Fourth Amendment, not the fact that the officer may find 1 out of 10 were here illegally and pull over 10 cars and maybe 1 is illegal? What about the other 9? Isn't the social cost the pretty much destruction of the Fourth Amendment?
I would argue, Your Honor, that the exclusionary rule is specifically a judicial remedy. So while Fourth Amendment violations may be brought about, the civil courts are a remedy for people to go about finding a remedy for this process. Additionally, there is internal discipline measures that can be brought about to reprimand the cops for bad policing. So this would be a remedy in that circumstance, and specifically in 1326 prosecutions, this evidence should not be suppressed because of the ongoing violation that is occurring.
Isn't it also a violation, not only by the officer, but wouldn't it be also a violation by his or her police agency, a violation perhaps by the United States Department of Homeland Security? I mean, how high does this go? And when do the courts come in and stop the agencies from doing something like this?
While the agencies also may be in violation of the Fourth Amendment, the illegality of the stop in this case is not contested, and the rights of there are remedies through internal discipline of those organizations, through the remedies as well for the defendant to have organizations that help them with counsel and defending themselves in the court.
A concession of the illegality of the stop goes a lot further towards us finding an exclusionary rule remedy than if there was no concession of the illegality of the stop. Wouldn't you agree?
I would argue that the exclusionary rule still can't apply because Lopez Mendoza defined, this court said the categorical rule that identity evidence is never itself suppressible, and because the fingerprints identify who Mr. Reyes Garza is, this court would not have jurisdiction over him, and this would have the same effect as suppressing jurisdiction. Thus, this court cannot suppress the identity evidence of who Mr. Reyes Garza is. Allowing a defendant to suppress identity evidence in 1326 prosecutions would permit the defendant to hide his true identity and undermine the administration of justice. In effect, it would achieve the same result as would allowing the defendant to suppress this court's jurisdiction over him. Lopez Mendoza never intended to give defendants such power. Rather, it expressly forbade the use of the exclusionary rule to challenge the court's jurisdictional power.
Did Lopez Mendoza envision giving the government such power as they exercised here?
Lopez Mendoza, the rule itself states that the body or identity of a defendant or respondent is never itself suppressible in a criminal or civil context. So this was applied in criminal cases in the majority of federal courts, including in Cuevas, Boley, Guzman-Bruno, Navarro-Diaz, and Del Toro-Godino. And so the Lopez Mendoza has been interpreted to apply in the criminal context and to apply specifically in 1326 prosecutions. Thus, if Mr. Reyes Garza could suppress his identity evidence, he would effectively suppress this court's jurisdiction over him. This would directly contradict this high court's formal holding that the body or identity of a defendant is never itself suppressible as a fruit of an unlawful arrest. Therefore, the simple fact of who Mr. Reyes Garza is cannot be excluded from this court. Additionally, while the petitioner has stated that there is a narrow exception for egregious violations, this court has never formally adopted an exception for Fourth Amendment violations under Lopez Mendoza. And even if this court did so today, the exception would be wholly inapplicable to the facts of this case. The traffic stop of Mr. Reyes Garza was not deliberately made in bad faith. It was not the product of race targeting, and under the totality of the circumstances test advanced by the Second Circuit and Zuniga Perez, the stop was not grossly unreasonable and did not involve verbal threats or abuse. Additionally, as a matter of law, the party seeking to suppress the evidence has the burden of establishing the widespread constitutional violation. In this case, that's the petitioner. Lopez Mendoza requires more than a violation of the Fourth Amendment. It demands egregiousness. Additionally, Officer James did not threaten or use unreasonable force, and Mr. Reyes Garza did not verbally object to or physically resist the fingerprint scan. Officer James, Your Honors, I see that I'm out of time. May I briefly conclude?
You may.
For the stated reasons, this court should Affirm the district court's denial of the motion to suppress Mr. Reyes-Garza's fingerprint evidence in his 1326 prosecution. My co-counsel Caroline Funk will now address you on the remaining two.
Mr. Chief Justice, and may it please the court. Notwithstanding the categorical bar under Lopez Mendoza to suppressing identity evidence in an 8 U.S.C. Section 1326 criminal prosecution, Mr. Reyes-Garza's fingerprint evidence remains admissible for two independent reasons. First, under Davis and Hayes, suppression is not warranted because Officer James did not arrest Mr. Reyes-Garza for the sole purpose of obtaining his fingerprint evidence. And second, under the Hudson cost-benefit analysis, suppression is unjustified. Contrary to petitioner's argument, Davis and...
I want to focus on the second part and kind of pose to you the same question we did to your co-counsel, which is, if we don't suppress the evidence in this case, what's to stop government agents, police officers, from just stopping anyone that they want at will and fingerprinting them? If it's not suppressed, what's the incentive for them not to violate that right of everyday citizens?
Your Honor, the government respectfully submits that there is low incentive to violate that right because identity evidence can be obtained in a number of lawful means. And to address the court's question about I-75 stops, it would require someone to challenge, and they could challenge, the executive administration's and the Attorney General's ICE directive, as oftentimes people do, and challenge executive orders. It could also allow for a class of defendants to bring a class action against the government for civil remedies, and the United States submits that that would be an effective tool to lower the incentive of this violation.
So you're saying the people who are stopped on 75 who are citizens could file a lawsuit, right?
They could.
And so if there's 100 people driving on 75 and 99 of them are citizens and they're stopped and they sue the police department's probably going to change their attitude real quick, right?
Yes,
And so you think that's sufficient?
I think that is sufficient and is an alternative remedy present. Contrary to petitioner's argument, Davis and Hayes does not require suppression. This court first held in Davis and later reaffirms in Hayes that fingerprint evidence may be suppressed only when police unlawfully arrest someone to solely obtain their fingerprint evidence. As explained by the 10th Circuit in Alvarez-Rangel, without a similar investigative motive, neither Davis nor Hayes requires suppression. For instance, when fingerprints are taken for the purpose of ascertaining legal identity or one's immigration status, suppression is not required.
But let me interject. Here, isn't it undisputed that the officer was acting pursuant to the ICE directive to go out and find people who were violating 1326?
Yes, Your Honor.
So why isn't the stop here purely investigative in nature?
While it is contended that the stop took place under the purview of the ICE directive, the dispositive factor in determining whether something is investigative or administrative nature is the motive of the arresting officer at the time of the arrest. For example, in Davis, the officers obtained the defendant's fingerprints to connect them to prints found at a crime scene. And similarly, in Hayes, the police detained a defendant specifically to obtain
So what was the motive of this officer?
In both cases, in both Davis and Hayes, the motive of the officer was to collect fingerprints and connect them to latent prints at a crime scene, which is investigative.
What was the motive of the officer in your case,
Yes.
our case?
We submit that, unlike the officers in Davis and Hayes, the motive of Officer James in this case was to ascertain the legal identity of Mr. Reyes-Garza.
For what purpose?
To specifically identify who he is, which we submit to this high court, that was in.
But for what ultimate purpose was he seeking to identify his identity?
The motivating purpose was to ascertain his legal identity, to confirm who he was, and that only.
Why, though? To confirm who he was for what purpose?
Because that is a legitimate government interest to know for an absolute certainty of who you have detained in custody. And I submit that that's both an obligation and a right of the government to know who they have stopped at a stop. Only when Officer James ascertained his legal identity by the fingerprints, only then did a deportation order arise, and only then did Officer James contemplate criminal prosecution. And I would submit that contrary to petitioner's argument, this case parallels, if not
Let me stop
mirrors.
you there. So what you're saying is the police have an administrative right anytime they stop someone to ascertain their identity.
Yes,
And that can be done, in your view, even if they provide a license, they can still just say, well, step out and I'm going to fingerprint you right now, every time. And that's unrelated to any law enforcement function?
well, in that case, officers can request identification, but the government submits that if a person provides a fake identification, that alone is a violation of the law. But to ascertain legal identity, that officers can use reasonable means to do so. And in this case, because there was a language barrier preventing Officer James from ascertaining Mr. Reyes-Garza's identity, the next reasonable means was that fingerprint scan.
All right, so you're not saying in every case. You're just saying because here he gets an ID from an individual from Hawaii, and then tries to talk to the person and he doesn't speak English, that gave him enough, I guess I'll call it reasonable suspicion that maybe this identification isn't correct, so he can then fingerprint him.
Yes,
And so your logic wouldn't be that any person who's pulled over, you can automatically fingerprint them, right?
No, I would submit that under the circumstances of each case, that an officer can use reasonable means to ascertain the legal identity of somebody detained.
But I'm still having a hard time wrapping my head around the fact that you've conceded the illegality of the stop. So what was the motive of the officer for stopping the defendant?
Your Honor, the government concedes that the stop was illegal. That issue is not preserved for appeal and would be improper to address before you. But the stop of Mr. Reyes-Garza's car was because it was dirty and mucky. And the government submits that
Is that a crime?
It is not a crime. And
So what reasonable suspicion then did he have of criminal activity?
The Officer James did not have reasonable suspicion to stop the car, and that's why the stop is illegal. But the dispositive question before this court is whether or not the exclusionary rule applies. That is a judicial remedy specifically for Fourth Amendment violations.
But you've not answered my question as to motivation. Why? You're saying the motivation for stopping Mr. Reyes-Garza was the muckiness of the car.
That's correct.
That strains credibility, counsel.
It does.
It strains credibility because the officer was acting essentially as an immigration agent under the 287G program, correct?
Yes, it is contended that Officer James was acting within the purview of the ICE directive in this case.
So, but you somehow want us to divorce that fact from the stop itself.
Yes, Your Honor, I believe it is sufficiently attenuated from the ICE directive. The dispositive factor is the officer's arresting motive during the time of the arrest. And while it was all happening under the context of this ICE directive, the motivating subjective intent and motivating purpose for Officer James in this case to fingerprint him was to ascertain his legal identity. It was not to connect them to latent prints at a crime scene. And he only fingerprinted him to ascertain the legal identity, which is a proper administrative purpose that many courts have recognized.
Just one more question on this. The murky vehicle, did it violate any South California code, any South California statute with regard to equipment violation, like an illegal tint violation maybe? We have none of that here, correct?
That's correct. The record is void of any such information.
Okay, thank you.
I would submit that this case parallels Oscar Torres from the Fourth Circuit. In Oscar Torres, the defendant was detained as part of a nationwide effort to capture illegal alien gang members. And although a criminal investigation, a national criminal investigation, may have influenced the detention and fingerprinting, the appellate court still held that the evidence obtained by the arresting officer could be admitted on remand if it was taken for an administrative purpose. And key facts to the court's holding included that the officers fingerprinted the defendant as part of a standard alien processing and contemplated criminal prosecution only after the fingerprints revealed prior felony and deportation records. Officer James acted with that same administrative purpose in this case. Even though Officer James may have been influenced by the ICE directive, the fingerprints remained admissible. Officer James fingerprinted Mr. Reyes Garza to verify his legal identity. And like the officers in Oscar Torres, only then did Officer James contemplate criminal prosecution when the fingerprints revealed the prior deportation order. Then,
So, if I'm understanding your argument, it is that if the purpose of gathering this information was administrative, then you win.
correct.
So I'm a little bit confused, though, about you automatically win in that case, but there's still an egregious circumstances exception to that. Can you explain the interplay between automatic win, but there's an exception that those two things don't seem to make sense?
Yes, Your Honor. Under Lopez Mendoza, some lower courts have recognized a limited exception for egregious Fourth Amendment violations. This high court has never formally adopted that exception, and even if it were to do so today, the facts of this case do not even come close to meeting that egregious violation. So we submit that under Lopez Mendoza, that categorical bar and rule crafted by this high court does
Well,
not
give me an
permit
example.
suppression.
I'm sorry, I didn't mean to interrupt. Give me an example of egregious circumstances. Let's say we do adopt the egregious circumstances exception. Give me an example of something that would be an egregious circumstance.
Yes, Your Honor. In Rochin v. California, the court held that there was a egregious Fourth Amendment violation. There, the officers used violence and force to detain a criminal defendant, bring him to a hospital, where the officers then directed hospital personnel to cut open the defendant's stomach and take out pills from the stomach. We submit that that's an egregious violation. It violated the dignity of that defendant. But here, the facts of this case, the case was and the result of the fingerprints came about during a peaceful arrest. Officer James did not use unreasonable force. He communicated with Mr. Reyes Garza, and only when that language barrier prevented him from ascertaining his legal identity did he use the fingerprint scan. So we submit to this court that there are no facts.
Counsel, he used the fingerprint scan after grabbing the petitioner's hand, right?
He did direct and...
So there's a law enforcement officer armed, acting under the color of law, grabbing somebody. That doesn't, at least in some sense, involve the use of force?
It does, but we submit that that's not unreasonable or violent force as the officers used in Rochin v. California. And another example where the court found an egregious Fourth Amendment violation was a nighttime raid of a defendant's home. And the home, recognized by this court, has one of the highest expectations of privacy. And so that was a violation of the defendant's dignity as well as the defendant's family's dignity in that case. We submit that the facts in this case do not raise to that level of egregiousness.
But after, I'm sorry.
No, please.
After the officer received the Hawaii identification, why, and looked at it, did not know that it was false. He only heard that a Hawaii identification could be false from his chief, I think it was.
That is correct.
Why wasn't the petitioner free to go? Like, what, was this a hunch by the officer? And I know we're getting into the stop, but you're saying that this wasn't egregious. He should have been free to go, no?
That is not the position of the government, and I would respectfully disagree, Your Honor. The Hawaiian ID that was provided to Officer James, he had a reasonable suspicion that it could be fake.
Because his chief told him that Hawaii licenses have been used as fakes, but he didn't have reasonable suspicion other than what his chief told him. You would agree that that was reasonable suspicion to detain the petitioner further?
Officer James received a fake Hawaiian ID, and that because of his officer's and chief's directive that he had reasonable suspicion. And the language barrier confirmed that reasonable suspicion. He then tried to communicate with Mr. Reyes Garza to confirm his legal identity, and that language barrier prevented him from doing something he had every right to do, which was to know the identity of the person he had detained. And only then did he use the next reasonable means to ascertain that legal identity.
How did he know it was fake?
He
What
had...
was the articulable suspicion that this was a fake ID as opposed to a real one from someone from Hawaii?
He had a reasonable suspicion it was fake because of the chief's directive, as well as subjective feelings during that stop. And then when he could not confirm the legal identity and asked Mr. Reza questions about his
Well, how could
identity.
he not confirm it? What do you mean when you said he could not confirm it? What did he do from the facts? I don't recall.
The facts in the record show that Officer James was handed the fake ID license. He scanned that and no hits came up. The license came back clean. But when Officer James then tried to communicate to say, is this you? They could not have that conversation because of the language barrier. And then he used the next reasonable means to ascertain that legal identity. Your Honors, I see that I'm out of time. May I briefly conclude?
You may.
Your Honors, we submit that the exclusionary rule is a matter of last resort, not a primary impulse. And for the stated reasons, the United States government respectfully asks that this High Court affirm the lower court's decisions and deny Mr. Reyes-Garza's motion to suppress of his fingerprint evidence, identity evidence, and his 8 U.S.C. Section 1326 criminal prosecution. Thank you.
Thank you. Counsel, rebuttal?
Mr. Chief Justice, may it please the court. The opposing counsel said that this does not rise to the level of an egregious constitutional violation and that it is not a widespread constitutional violation. However, Lopez-Mendoza specifically stated that a widespread constitutional violation, although never previously addressed by this court or any circuit court, was a viable alternative to find, and the dissent noted that it should be remanded for that issue. As Your Honor said in your example, that you could be driving down I-75, stopped by a police officer, asked to give your identification with no reasonable suspicion, and then your only remedy would be to file a civil suit, even though your constitutional rights were directly violated. That right there, which is exactly what is happening in Operation Mass Sweep, represents the exact type of widespread constitutional violation that was addressed.
When you talk about that and we go, I'm going to fast forward to the balancing test that we have to do. I think it's under Burton, and I apologize if I'm using the wrong, I'm sorry, Hudson. So why isn't that threat of the civil suit, if the officers are going to just go about and detain people at will, a normal citizen, why isn't the lawsuit that's going to follow enough of an incentive for the police officers not to do that? Because that's what we're really concerned about, is the overreach. But isn't the civil suit enough to curtail that potential overreach?
Your Honor, as you had stated previously, multiple civil suits likely would give rise to a change within the police department. However, one suit in and of itself is unlikely to immediately resolve that issue and would allow the ongoing constitutional violation of United States citizens. And they are told that the civil suit would be the only remedy, yet it would take time, money, and resources in order for multiple civil suits to eventually culminate in a recognition that the police department is violating citizens' Fourth Amendment rights and that changes need to be made in order to ensure that people's constitutional rights are safeguarded. Additionally, Your Honors, to see my time has expired, may I briefly conclude?
Okay.
Your Honors, for the reasons set forth by myself and my co-counsel, we urge this court to allow suppression of Mr. Reyes-Garza's fingerprints. Thank you.
Thank you, Mr. Collins. All right, counsel, thank you for your argument. Are we going to adjourn?
Do we retire?
All right.
Hey everybody, it's me again. So at this time, first, congratulations to all 4 of you. You guys did phenomenal. You guys did great. Very proud of all of you guys. Give them a round of applause. So at this time, I'd like to recognize a few of our standout competitors. If I call your name, please come forward to receive your certificate. 2 of the names that we're going to say are not here, so let's just give them a round of applause anyways, but that would be Caitlin Bonema and Derek DiCrescenzo. And the other semifinalists were Anthony Colello and Alex Wiesner. Next, we have the finalists, as you heard, Marie Carney and Caroline Funk. You guys want to take a picture for Lisa real quick? The other finalists were Joseph Collins and Jacob Wade. And also, the highest brief score for this year's Bork competition was also belonging to Joseph Collins and Jacob Wade, so that's a double one. And just for the picture.
We're going to need to make another highest brief score.
can be seated. Well, congratulations to all four of you on a job. Yeah, well done. I'll let everyone else speak as well. I figure we will go ahead and announce we were unanimous on the winning team along with the winning advocate. So I'll go ahead and announce those, and then I think we're going to have a few minutes to just make general comments and whatnot, Professor Bonner? Yes, sir. All right. So to start with the winning team, it was very close. You all did a great job. Caveat to each of you on that. But the winning team was the government's position, or the government's team, sorry. You both did excellent, great job. So you are the winning team. And as for the winning oralist, that was also very close, and that goes to Ms. Funk. So congratulations. Okay. So do we want to talk a little bit? I'm going to pass it over to the dean to start. No, you're on my left. You've got to go.
First of all, congratulations. Thank you for the amount of time you put into this. I was very, very proud to be dean of this law school and have this high level of advocacy. This problem was outside of my area of expertise, so I will let the two experts on the panel discuss sort of the substantive issues. What do I want to say? I echo what Judge Dudek just said. That it was a close call on both counts. Speaking for myself, I thought the government had a losing position, but that's a personal opinion. But your team did very well. Gentlemen, you also were excellent. You just ran into a team just barely got you. I think I'm going to stop there and let them talk about the substantive issues. I'll say one more thing. Each of you had very professional demeanor. I thought all of you commanded, if that's the right word, had a good presence, good command of the case without a doubt. And so we may have some comments about organizing the arguments, et cetera. But overall, I'm not being very helpful. You all were extraordinarily strong. I'll let these two seasoned jurists and state attorneys comment on the professional quality of you all students. I'm biased. I think you all are ready to go out there and start litigating, especially with some more seasoning. But anyway, I'll shut up.
All right. Well, to echo some of what was just said, you all did a great job. I see lawyers all day. You were well above what I typically see. I know that might sound crazy to you, but you were all very prepared, ready to speak intelligently on the issues, had a good grasp of the facts and the law. So kudos on that. Just a few, because things I had questions about, wanted to point out. Mr. Wade and Mr. Collins, one of the things I thought was strange, and maybe you can fill me in as to why, and maybe I missed this, but we all had it. Did you concede the jurisdictional component of the Lopez case, that it was, I had it written down that in your opening, Mr. Wade, that as for the issue of whether Lopez Mendoza stood for an evidentiary versus a jurisdictional hurdle, that you said that it was evidentiary?
I don't recall specifically what I said.
Didn't you have that?
I thought so.
Yeah.
So.
And I thought the jurisdictional issue about Lopez Mendoza, meaning that its exclusionary language and whatnot was just a jurisdictional component, not evidentiary in nature at all. I thought that line of case law was actually very persuasive. And from your opening statement, I thought you had conceded that, so I just wrote that off the board.
I had the same reaction. I mean, it's interesting.
So maybe if you did not mean to concede that, then maybe it was just lost in your opening. But that's what we all picked up from it, and I thought that was a good argument that could have been made, primarily because it was a winner, meaning in the sense of if you won on that, you didn't have to go down the balancing test or all the rest of the factors. We could just say, hey, it's jurisdictional. It's a jurisdictional issue, and end it right there. So that was a question I had. I thought you both had good command of the questions and what you had in response in the case law. Mr. Collins, one of the things I thought when you got up is you reintroduced yourself and your co-counsel. I would probably just say, Your Honors, your name again, as opposed to doing the same exact introduction that you just did, that Mr. Wade did, because we were just here. We just heard from him, and I think it would have been, Your Honors, just to refresh your recollection, my name is, and then say, I'm here to address, and then move on from there. Whereas you had I would almost say your opening was like if you were the first counsel to argue. That was just a small thing. Other than that, I thought the two of you did a fantastic job. On to the government brief. Ms. Carney, you seem to get flustered by a lot of our questions, which is okay. That happens. I mean, that's what they're designed to do. So I would say that was just the biggest impediment for you, was trying to pick up from where we left off in some of our questions, because they were tough. You guys had a tough position. So I thought that was probably the biggest, but the only way to get better at that is just through repetition, through practice. It's like going to the gym. The more you exercise it, the better you get at it. So, but I thought that was the biggest comment I would have to you, is to listen to our questions, try to think about them and answer them, and that will probably serve you well in the future. Ms. Funk, you were the best oral advocate at consensus, so you did a great job. We thought you had a good I thought you had a good transition from our questions back to your points after we stopped asking. You had a great command of the case law, kudos.
Thank you, Your Honor. Gentlemen, you lost the battle here, but I'm not sure you would have lost the war if we were to write an opinion. So take note of that. I think you had the stronger position. Part of this, I am learned in the Fourth Amendment side of it and the criminal side of it. I do not do immigration law. It's not within my purview. It's generally a federal purview. So for me, combining or trying to differentiate between the administrative idea and the criminal investigative idea was something that I had to deal with. I'm a prosecutor 31 years, so your position, government, really smacked of some serious issues that I had as a prosecutor, and certainly things I would want to avoid having to argue as a prosecutor in a suppression motion. And there have been a number of times I thought I won the battle, but ultimately would lose the war, right? Because I thought I would give a great presentation to a judge, and then judge hands me my lunch in his or her order, granting the motion to suppress. So it was a very difficult problem, but certainly a difficult problem for the state or for the government. Just interestingly enough, with the modern day, and if you follow Florida law, we as prosecutors now on the state level have been given some authority to prosecute immigration and status crimes from our legislature. Whether that gets upheld on appeal going forward, who knows? But it did make for a very interesting problem for me. Just in terms of arguing, just slow down sometimes. Obviously, you're working off of a script, but the script is never something that you're going to be able to rely upon, no matter what, whether you're doing appellate argument, whether you're doing the questioning, the examination of witnesses when you're at the trial level. There's always going to be an impediment put in your way. For you today, it was us. We were your impediment. And the key is that transition from what you know you want to get out, and what you have to answer in response to our questions. And some of the questions are gotcha questions. Absolutely. Some are to see how you react under the pressure, and whether you've thought through. And I thought, Ms. Funk, some of your transitions, like His Honor said, were just very, very good. You're able to answer the question. I don't know if you satisfied me in some of your answers, but you were firm, you had a conviction, and you gave your answer, and then you moved on. And that's what you have to do. Don't doubt your answer. Don't ever doubt your answer, because we see doubt. We see it. And if whether it's a jury that's you're going to be in front of someday, or an appellate panel, the folks that are looking at you sense that doubt. So you have to have that conviction of your position. And sometimes that can carry the day. Certainly with a jury, it can carry a day sometimes. So are you 2Ls, 3Ls? What are your yours?
I'm a 3L.
You're 3L, 2L, 2Ls? You're on course here. You really are. And may I suggest you come be trial litigators at the state attorney's office. Because if you want to get, you won't get an appellate bank like this to argue in front of, but you'll have a single judge and a jury of 6 or 12 to convince, and you are on your way. So congratulations to you on a very complex problem. Very complex problem, very timely problem, but also a very complex problem that's wrought with not just the law, it's wrought with politics and public opinion. And that puts pressure and strain not only on the lawyers involved, but also on judges who have to make decisions bounded on the law and not necessarily on public opinion or political pressure. And you will face that as you go forward as attorneys in probably whatever area or whatever field you practice in. There are going to be elements of all of that. So congratulations, and keep on keeping on, and graduate and become lawyers, because Florida needs good people like you. All right.